You may have missed it late last week, but the Supreme Court decided to hear 8 new cases this term, and there is one that not a lot of people are talking about, but I think you're going to be interested in. It has to do with free speech and online stalking. The very relevant and interesting question at the center of it all is, at what point does a person's free speech stop and a true threat to someone else begin? Full disclosure, this has happened to me repeatedly. Police have gotten involved, and I know I'm not the only one. There's a lot of women out there, and some men, that have had to deal with this very same thing, so I suggest you pay attention to this case. The Supreme Court has decided to hear Counterman versus Colorado. Billy Raymond Counterman was convicted of sending upwards of 1 million Facebook messages to Coles Whalen, a female musician in Denver. Counterman's messages were sent over multiple years, and according to Whalen, were creepy, weird, and became stalkerish. She blocked him repeatedly. He kept finding ways to send her these messages. Whalen became fearful, withdrawn, and anxiety-ridden. She even stopped booking shows because she was afraid Counterman would show up and hurt her, or worse. I can't explain his messages any further because this video would be taken down, but you get the picture. Police ultimately arrested Counterman in May of 2016, and a jury convicted him of stalking. A judge sentenced him to 4.5 years in prison, while Counterman appealed, saying the state's stalking laws infringed on his free speech. Colorado's laws say stalking can occur when a person repeatedly contacts, surveils, or communicates with an individual in such a way that a reasonable person would be afraid or feel serious emotional distress. The courts found that Counterman, through those 1 million messages, was a true threat to Whalen. But Counterman's attorneys say he didn't intend to make a threat, nor did he know his 1 million messages that continued even after being blocked repeatedly would be perceived as a threat. So the question before the Supreme Court now is, what is a true threat? Is it enough that a reasonable person would see a statement as a threat, or is it up to a prosecutor to show the person making the statements knew or intended the statement to be a threat? The Supreme Court has established that true threats do not have First Amendment protection. So to be classified as a true threat, someone has to communicate a serious intent to commit violence. But what we've seen repeatedly in these types of online stalking cases is it's not often just one explicit message that conveys a violent threat, but all the messages in context and in totality that become threatening. It's likely the Supreme Court will be hearing this case in April.